It's the pregame show. It's gonna be a short pregame show because I'm just gonna hit the go live button. Let me, oh, and we're live. It is Monday, February 28th, 5:02 p.m. Eastern Time. And I thought I was going to say 2 p.m. Pacific Time, but Doug is actually not on the West Coast. And so it is just 5 p.m. for all of us. We are not allowed to have fun anymore, but we are allowed to have Doug Melamed on the show to talk about antitrust. And your new paper about mergers involving nascent competition. So welcome to the show, Doug. Thanks for coming on.
Well, thank you. I'm looking forward to it.
Yeah. So I don't know, get us started. We were talking before all of this just kind of about, you joked that no one's thinking about antitrust at the moment, given everything else that's going on in the world. But I'm curious, and you said something that I thought was interesting, and I do think it's kind of like a cool way of thinking about how antitrust, like kind of fundamentally describing antitrust. So go ahead.
Well, I was just saying that you could, if you were trying to find a way to connect antitrust to make it relevant in light of the preoccupation for all of us of what's going on in Eastern Europe, one could say that like what's going on in Ukraine, antitrust is fundamentally about the issue of what do you do about or how do you prevent aggregations of power in society.
Yeah, I think that's really interesting. It's also kind of speaks to the idea that there is this I think it's interesting. There's this interesting kind of trade-off with antitrust in which it speaks very broadly to these ideas of power, which frankly are kind of amorphous and hard to pin down. And then the doctrine of antitrust, how it's enforced by the courts, how it's understood, I mean, has all of the hallmarks of basically any kind of economic effort, which it just tries very, very hard to quantify subjective kind of determinations like power. And it's all about kind of line drawing around what the market is and line drawing around what the harm is and the harm to who and the harm to certain consumers and power, all kind of reduced down to those elements. I don't know, what do you think about the new movement, like the new kind of antitrust movement that pushes for kind of a little bit more subjectivity getting read into kind of antitrust doctrine?
Yeah, I think the word subject or subjectivity is really key. I would quarrel a little bit with your framing the issue by characterizing antitrust as it exists now as an effort to draw lines around a fundamentally subjective determination of power. And I say that because I think what antitrust has tried to do for at least 40 years is minimize subjectivity. A great epistemological question here, but minimize subjectivity by defining the relevant power as market power in the economist's sense of the word. That is to say, the ability profitably to raise price or otherwise act to the detriment of a trading partner. And that's supposed to make the test objective. And then there is, as you say, the doctrinal question of all the rules that are supposed to implement that test. And I think those have gone too far in an area, have been too cautious. We can come back to that, of course. Now, the current controversy, or at least the noisiest part of the current controversy, from the so-called progressives or new Brandeisians, Tim Wu in the White House, Lena Khan at the FTC, and so on. And they, I think you're quite right, are explicitly saying, let's abandon this purportedly objective focus on economic power and be explicitly subjective in what we're talking about. This is a crude shorthand, in an effort to move toward a kind of Jeffersonian, vision of Jeffersonian democracy. And to me, the fundamental issue that raises is the following. Antitrust law in our country is a law of general application. It applies to almost all forms of commercial conduct that affects interstate commerce. And it's a decentralized law in its enforcement. It can be enforced by anybody who can plausibly claim to have been injured by a violation of the antitrust laws in any of hundreds of federal courts around the country. So to me, the question is, how do you, consistent with the law, have a body of rules that is as subjective as I think the New Brandeisians, as progressives, want it to be, without running an unacceptable risk of arbitrariness, unpredictability, and ultimately, I think, capture of the decision makers. And that, to me, is the central issue posed by the proposals from the left. I don't really quarrel with their distributional values, but I do quarrel with their sense of what makes sensible.
So I want to ask you something else about the proposals from the left, and which has bothered me since the Microsoft case, which was, among other things, brought by you guys, and was not particularly associated with the left. But Microsoft's response to this, of which I was dismissive of the time, was, hey, we're building additional functionality into our operating system, including what we used to think of as a separate program. A browser makes sense as part of the operating system, which back then the Justice Department took the view, and I agreed, that's ridiculous. You're binding an unrelated product to an operating system. And in retrospect, Microsoft was right and we were all wrong. Now I use a Chromebook that's the entire operating system is a browser. And the idea that you would have a browser with an operating system without a browser bolted to it is, like driving a car without wheels. And so I look at it and I say, this is a paradigmatic situation that antitrust law keeps getting asked to deal with, which is big, powerful company moves into a new area and attaches what we had used to think of as a different product, a messenger, to its core system and integrates it. And we go, and by the way, doesn't charge for it. So it's very hard to articulate what the consumer damage is. They're getting a free thing. And so I guess my question is, it isn't the fundamental demand of the left, which is these companies are too big and they're all trying to do everything, which is creating these monocultures. It seems to me there's an analytic problem with it, which is that what they're really arguing against is horizontal integration of software in the form of platforms of precisely the type that we all, looking backward, absolutely demand in all of our products. And I guess my question is, and I've been very inarticulate about this, but isn't there an analytical problem with telling companies not to give more away for free?
I'm not sure it's an analytical problem, but it does sound like one that makes the recipient of that free gift unhappy. By the way, I love your T-shirt. I hadn't noticed it till a minute ago.
Thank you. I try to
they're like a whole shtick. They're like
I only wear dog shirts on in lieu of fun.
Oh, I see. Okay.
And increasingly at all. But
yeah, well, of course, many of us have a dog that reminds us of it, or had a dog. I think you're quite right, and that's really, to me, if I had to put in one sort of phrase what it is that separates me from the New Brandeisians, it's that they want to ignore and in fact regard as dangerous the whole concept of efficiency, which is kind of a shorthand for growing the pie, economic well-being. And to me, that's central to a prudent government policy in this area. I do think, and this is important, I do think that when you say Microsoft was right and the government was wrong, I think what you're saying is they were right with respect to their rhetorical framing of the issue. The government, in fact, the U.S.
Yeah, no. I just to be clear, Microsoft rightly lost that case, or had to lost that case in the D.C. Circuit on matters related to bad acts by a monopolist that were prohibited, that had very little to do with that specific framing issue. So I am in no sense defending Microsoft's conduct in the antitrust case.
I understand. But all I meant to say is the federal government case did not challenge Microsoft's inclusion of a free browser with the operating system, precisely because although we weren't clairvoyant enough to know how the world, would evolve, we were very mindful of the notion that the antitrust shouldn't stand in the way of innovation, technological improvement, and the like. And to stand in the way of it is to pay a huge price. And it's, not to say one can't argue, well, we need to pay that price to preserve other values in society, but it raises the question of how do we know that? How do we compare the gains and losses? And then, of course, the second order question of whether antitrust is the right tool to deal with that big question of how do you deal with evolution? But yeah, a lot of what's going on now is a statement that the tech platforms are getting big because they are following a path that seems to be driven by technology and by economic efficiency and user desirability, and that makes them bigger and more powerful, and that scares some people.
I'm kind of interested. There has been, I think it was Fiona Scott Morton has written a number of articles about kind of new antitrust and some op-eds. She's an economist at Yale, at the School of Management. One of the things that she said is that to kind of get back to the point of subjectivity and objectivity is that there is something about the new antitrust neo-Brandeisian movement that is tapping into kind of an emotional core of what people are feeling about technology and the power that it has over them. Of course, like as we were kind of talking about a second ago, like the objective ways that antitrust has tried to draw these lines and to kind of create these definitional like categories, attempts to kind of, I don't know, I guess say I would like take us out of kind of those subjective types of realms. Do you see this as kind of like, do you see this as do you see the courts basically as making it possible to move a little to like, is it a one-way ratchet, I guess is what I'm saying, is the move towards more and more objective kind of definitions in antitrust and doctrine? Is that something that the courts can't necessarily undo? Or is that something that and that we're going to have to rely on legislature, like Congress, to basically to like redefine? Or do you think that there is some room for courts to kind of move backwards towards kind of slightly more capacious or less narrow definitions of things like consumer welfare tied to price is like one example that Lena does in like Amazon antitrust paradox?
Yeah. Well, first let me say of Fiona's comment, I think there's no question that the antitrust progressives have tapped into a broad populist foment at this time in history. Trump discovered it on the right. They're exploiting it on the left. I think there are a lot of common themes of distrust of the establishment, distrust of anybody with power. There's no question about that. As to your specific question, antitrust has been regarded and criticized by some for this, but has been regarded for 100 and some years as basically a common law type of discipline with very vague general statutes and law made by courts in a kind of common law or evolutionary or constitutional law-like process. And what the courts make, the courts can improve. And I think the courts have gone way too far in many areas toward the defendants. They started with a notion, particularly galvanized by an article by then Professor, now Judge Frank Easterbrook, now on the Seventh Circuit.
Wait, is this the breaking up is hard to do? article or another one?
No,
Sorry.
This is
There's so many.
yeah, I forget the title. 1983, 84, whatever. And in Texas Law Review, by the way. One of the points in that was that a false positive, falsely finding someone to have engaged in a violation of the antitrust laws, is more damaging than a false negative, mistakenly failing to find a violation, because the market can correct a false negative, but a government decision, there's no suitable mechanism to correct it. Now, I think that was an underspecified and probably largely incorrect observation 40 years ago. But even if it weren't, and I think it probably did at the time help correct some excesses in the other direction, there's been a lot of ideology and a lot of inertia that has taken that basic notion far too far. And so many sort of micro provisions, micro doctrines about predatory pricing law, about exclusive dealing law, about mergers, have time and again said, oh, we got to avoid a false positive, and it caused the law to go much too far in favor of defendants. And there's no reason why judges can't correct that and say, well, we learned that was wrong in the common law process. Law can, evolve back and forth. The problem for those of us who would like to see the law evolve that way rather than become a political football in Congress is that the courts are very conservative. The Supreme Court is, it's quite ideological on these issues and very conservative. And it's going to take a long, long time if we rely on the courts to do that. But in principle, sure, they can do it.
So I want to ask about what the alternative to that is, because, this stuff is almost all statutory, although I suppose there are some constitutional underbrush that a Supreme Court that was hostile to the text of the statute might look at. But by and large, this stuff is statutory. And while the Supreme Court has a lot of latitude to change the law or to sort of work within the confines of fairly broadly worded statutes in the direction that it wants to, one solution to the problem would be, hey, we don't want to wait for the courts. The new Brandisians are proposing something profound and in your view, wrongheaded. Maybe the answer is an alternative congressional framework or undoing some of the excesses of current doctrine legislatively, but in a fashion that is more, a little bit less radical than what is currently being proposed. And so I guess the question is, from your point of view, is there a constructive role for Congress to play, or is the allure of the new Brandisian approach so strong that once you open the box, you're going to get swamped by the, Josh Hawley, Elizabeth Warren axis?
Well, I'm not sure what the outcome will be of a legislative process, whether the Warrens and Hawleys will actually prevail. My guess is if it's targeted at the big tech platforms that everybody seems to want to beat up on these days, they might get something done. Broader antitrust reform, it seems to me that unlikely. I said, I think, in a session like this with Josh Wright at GW, former FTC commissioner, I'm sure you know who he is. He's pretty conservative. George Mason, he is a George Mason kind of guy. But I sort of said, and I believe this, Josh, if he and I could sit down together for a few hours, we could probably draft and improve legislation. I don't know that Congress can. And more important, I could probably select a group of 10 people that you'd probably label more or less correctly as center left, center right. And we could probably sit down with a spirit of goodwill, come up with a law that would maybe improve things. Leave aside whether the precedent of getting Congress involved would be dangerous, because next year they might be listening to somebody else. But I don't think a larger group could do that. And I'll give you a little example. I was involved in a group of people, all of whom I respect and I agree with on 99% of our things. And we all would be characterized as center left and probably despised by the progressives. As sellouts and the people who were in the government when all these terrible things were supposed to have been happening. And we were trying to come up with a legislative proposal and talking to some folks on the Hill about it. And this group of maybe 15 people of goodwill and really largely common values, we could not agree. At the end of the day, maybe 2/3 signed on and then some didn't. And the reason was that there were some very tough issues there. So it's a really tough problem if you try to do it nationally.
So let's drill in on that. What are the sticking point issues that prevent, even a group of generally like-minded center-left people in this area from being holistically on the same page, let alone reasonable center-right people?
Well, if I had to summarize the points of disagreement at the end of that process, I think I would say it comes down to this. And I'm going to overstate it to oversimplify them. I don't mean to be pigeonholing people. The economists in the group focused, not surprisingly, on what is the sound economic result. And the lawyers in the group, many of them, Tim Wu has a phrase you may have heard of describing a lot of people as lawyers masquerading as economists. And I probably
Isn't that him?
What? Well,
isn't that also him?
In his case, I'm not sure it's a good masquerade, but in any event, I probably consider myself one of them. But we were still lawyers by temperament and training. And I think where we separated ourselves, and I'm not sure it was actually lawyers and economists, but it kind of directly indicates the difference, was that we were more concerned than the economists with the following question. How do you articulate a legal rule that a district court in pick your state, a judge who gets one antitrust case every 8 years, in a case brought by a plaintiff's lawyer who couldn't care less about the public interest and just wants to shake down the defendant for some money, and a defendant who couldn't care less about the public interest because he just wants to get away with his anti-competitive scheme. How can you articulate it in a way that will send the right signals to the business community and the legal community and be administrable by generalist judges around the country? And so that leads what I call the lawyer group to be a little more cautious about simply writing down the economically correct legal rule. There's a translation process that we think has to take place. And that process has been done by the courts to excess, but I wouldn't be willing to go as far, frankly, as some of my friends in kind of minimizing its role. Yeah.
So I want to talk a little bit about the paper that you mentioned. I'm going to drop a link in the chat. The mergers involving nascent competition. You're going to have to probably define some of those terms for the audience, but I'm interested. I looked it over, and I think that this is kind of a fascinating topic to come out of the FTC v. Facebook litigation right now.
Well, it is, and I had written that paper for another reason. I'm very uncertain what the right answer is, and after the district court predictably denied the motion to dismiss the amended complaint in FTC v. Facebook, I thought, people are interested in this topic now, so I put the draft, kind of a working paper thing on SSRN. Look, here's the problem as I see it. It is what happens when a dominant firm, Facebook, for example, acquires a so-called nascent competitor, by which I mean a much smaller firm that has not yet reached what one might plausibly imagine to be a mature state. So it acquires that firm. And what do you do with the risk, which is probably kind of a black swan event? I don't think it happens every day, but the risk that, if we hadn't let Facebook buy
Instagram and WhatsApp,
Instagram or WhatsApp, one of them might have evolved to the next big thing and might have revolutionized social networking in a way that we can't even imagine today. What do we do to guard against the risk that these acquisitions lead to that result, bearing in mind that one of the principal motives of the acquiring firm might be to prevent that possibility because it doesn't want a disruptive innovator in its space. Some people would say, well, none of these are going to have important efficiencies. Why don't we simply say, if you're a big firm, you can't buy anybody? I'm not there yet because I can imagine lots of reasons, and their data would suggest there are lots of reasons that are benign to these acquisitions. But it raises a really serious question because the last thing we want is, it seems to me, is to allow economically powerful entities to interfere with the very innovation process that is at the heart of economic welfare over time.
Ben, you look like you're going to say something, but I also have like a follow-up question, which is just basically that I was curious. This is one of the things that is so hard for me about antitrust generally, which is that it's, I was just reading, I'm actually just working on I was just going over the history of like the AT&T breakup, for example, or Ben was talking about Microsoft earlier, and you have kind of absent any antitrust intervention around competition, like Apple just really dipping in like the 90s and almost becoming slightly irrelevant for like long periods of time. And so like one of the things that has never been totally obvious to me, and I'm sure that, I'm not like alone on this, but is like the both like the fact that for a lot of these kind of interventions to create competition in the market, these are not they're kind of confounded experiments. They're not particularly controlled. And then like two, that basically like the sample size of comparing each intervention to the future intervention is just like so, in order to bring around a certain effect, is like so mercurial and kind of and fact, every case is so fact dependent and like so kind of completely cabined by time, the time it took place and kind of the environment in which it was taking place. So I just kind of, I don't know, like I think that there is something about antitrust that I just fundamentally don't understand, that there is like this, I feel like it's this interesting balance of trying to constantly create these objective definitions and everything else, and these tests matched with kind of what is essentially just unknowable kind of outcomes, and not being able to directly ever be able to decide that, that AOL broke up because of the terms of AOL broke up, but AOL kind of diminished in its power and capacity because of the terms of the merger with Time Warner, for example, like things like that. Like it's unclear.
It is unclear. I have a device that it enables one, I think, to some extent to duck the implications of that question. And here's what I mean. So I said earlier that antitrust law is a law of general application because it applies to almost all commercial conduct that affects interstate commerce. And what that means is that the vast majority of the overwhelming importance of antitrust is found not in the litigated cases, but in the anti-competitive acts that are deterred by a sound antitrust law. And this is the benefits of antitrust. And by the efficient, pro-competitive, welfare-enhancing conduct that is not deterred by an overbroad or unsound or ambiguous antitrust law. So what I mean is, we focus on the big case. We ask,
That's a great point.
Look at the Microsoft case. Was it rightly decided? Did they get it right? And then, of course, the second order question, did the remedy matter? And my point is, that's not really the central question. The question is, did the Microsoft case send signals to the economy, to other big firms, that overall are going to optimize their behavior?
Well, and also, does having a unanimous DC Circuit and bank
Sure.
That actually articulates, like, at 125 pages or whatever it was, this is not okay. Does it send very powerful signals to the next Silicon Valley? Not that Microsoft's in Silicon Valley startup, about what kind of chest thumping, sort of turbo male competitiveness is actually not okay.
Yeah, and my guess is that was an extraordinarily valuable decision precisely for that reason. Regardless of what you think of the particulars of the browser war or the particulars of the remedy in that case. And so to me, what we ought to be looking for when we analyze these decisions, I mean, it is interesting to say, did they get it right? Was the AT&T breakup right? Was it okay to let this merger go through? What lessons can we learn from the Time Warner AOL or the other Time Warner AT&T thing? But as a policy matter, I think the larger question is this body of law sending the right signals? Is it optimizing the deterrent value of competition law in this country?
So I want to ask a market definition question, which it seems to me all of these cases and all of these antitrust questions ultimately hinge on market definition questions that are sort of non-obvious. Is Facebook a monopoly? Well, it depends what you think it's a monopoly in. Is it, it's certainly a monopoly in giant platforms with blue thumbs up signals, as right, like, but I actually don't use it very much. I use Twitter, which suggests that for my social media needs, it has competition and it's out-competed, except for providing me the beast of the day, which is, a very Facebook-capable thing. And similarly, as I've thought about it, and it's less true in the social media space, but it's true in a lot of these spaces, that there are really 4 companies that are doing almost everything a given consumer would want. Google, Amazon, Facebook, Apple. And, they all let you send money to people. They all let you send messages, except Amazon. They all, the overlap of their offerings, they have different emphases and different self-presentations, but they're allowing the overlap between what Google permits a user to do and what Apple permits a user to do is astonishing, right? And so I guess it seems to me I can define any of them as a monopoly if you focus on sort of micro parts of their businesses. But if you focus on the macro part, I suppose with the exception of Amazon, which does do a certain amount of, like, a huge amount of brick and mortar, sending people things that they want to buy, they're actually doing a huge amount of the same stuff, which suggests that there are 4 major companies that are all competing with each other. So I guess my question is, what's the right intellectual strategy for defining markets in a world in which, you can't say this is the only train track between X and Y. You have to say Alexa and Siri are really, competitive products.
Well, I think that's a great question, and there are some people on the right of the antitrust political spectrum who have been saying for a couple of years, look, the most important contribution to each of these major tech platforms seems to be coming from the other tech platforms who have the resources and the incentives to expand their business in a way that brings them closer to one of the other platforms. And that's why we should be very reluctant to intervene in a way that prevents their expansion and all these self-preferencing and horizontal separations regimes that people are proposing is exactly the wrong prescription. I think there's a lot of wisdom to that. But I think the answer, given the antitrust law as we now know it, to the question you ask, goes something like this. The antitrust laws are not anti-bigness. They are about bad conduct. All of the major provisions of restraints of trade.
Yeah, it's monopoly and anti-competitive conduct. It's not just monopoly, right?
So the question then is, well, all right, it's about bad conduct. How you define the bad conduct? Well, we say, a lot of the bad conduct requires some screening to assess the power of the firm that is engaging in it, or the consequences, the power consequences of the conduct. In the latter case, because we don't want to waste time on the trivial stuff, one wheat farmer burns down some wheat of a neighbor, that's not an antitrust problem. And the other is because some conduct matters only if the firm engaging in it has power. But if you look at the question that way, you can then define the power question by saying, does the firm have power with respect to the domain in which this conduct seems to be taking place? And that might be a very narrow domain, it might be a big domain, but there's a kind of a functional purpose to the definition of market power in that context. It's not the kind of the question writ large, does Apple have market power and is it actually competing with Facebook? That question rarely comes up in an antitrust case.
Yeah, absolutely. I don't know. I think that I want just really quickly, and then we're going to go to user questions, or viewer questions. I'm kind of wrestling with this right now because I've been kind of dealing with this paper that I'm doing. It does not take on the doctrinal kind of stuff around antitrust at all. It doesn't take on the likelihood of success or do any analysis about how this case should or should not come out. It just actually asks the question, if you use structural breakup, will you make a specific set of platforms like user-generated content platforms, so including Facebook, but I draw the market definition slightly different than the FTC, but will you make the public sphere and the operation of those? Will you make the individual user experience of them better through breakup? And I'm just curious whether you see, as you said before, the specter of regulation, the establishment of certain rules, the idea, the existence of antitrust, the possibility of antitrust enforcement as the new call for the structural breakup is almost trying to reset that in kind of appealing to this very extreme type of enforcement mechanism for the specific intent of basically chilling acquisitions in nascent firms. Facebook has not, for example, kind of had this. Facebook has kind of ceased to type of acquire. I mean, it is actually, Meta is picking up a lot of stuff in the XR space and all this kind of stuff. But I'm just kind of curious, do you think that that's that's a purposeful thing that people are very much aware of and that they're that's why they're doing it? Do you think that they genuinely believe that the answer for making these platforms better is to increase competition? Just totally by breaking up firms?
Well, of course, it's hard to know. I'm not sure exactly what people you're referring to in that question, but I think a lot of the motive for folks who are saying we got to break them up, in other words, leave aside the bad conduct thing of existing antitrust, we have to break them up. I think the concern there is they're too powerful. And I think the fact is that if you broke them up, you would lose a lot of current efficiencies.
Yes.
Imagine going on Amazon and having access to only a fourth of the inventory that you can now go. I always have said to reporters who call me up, I say, go back and ask the guy who wants to break up Microsoft whether he's a member of Amazon Prime. I'll bet they all are. We all value that stuff. It doesn't mean to say it's the end of the conversation, but it means that I think the impetus to break them up, at least in the short run, is to say we're willing to pay the price of a lot of of a lot of lost efficiency in that respect. Now, there are two arguments why that's still a good thing. One is simply kind of distributional Jeffersonian populist view. We don't like big companies. End of story. But we're willing to pay that price to avoid big, powerful companies. The other is only if we break them up are we creating an environment in which innovation and entry will flourish. The little guy's not going to be gobbled up or by acquisition or stepped on by aggressive predatory conduct, and that's the only way in the long run to create an environment that will optimize the well-being of consumers.
Tell that to TikTok, though, right? And
yeah,
I mean, I think that point is so self-evidently wrong. That
Which point? Which point specifically?
The point that a competitive environment and innovation cannot survive the size of these companies. And I'm uncomfortable with the size of these companies. I kind of believe in the curse of bigness. I'm not a apologist for these companies at all. But you simply can't look at the last 30 years of American tech and say, boy, there hasn't been innovation. There hasn't been, small companies can't break through. This is
literally was just writing this part of my paper. I was like,
it's a completely indefensible
TikTok
proposition.
in like 3 years surpassed the 3 billion user mark that it took Facebook 15 years to do, and is doing it without use of the social graph, which kind of adheres people to like certain like supposed network effects. So like I agree. Yeah.
I mean,
I kind of agree with that, but there are two kinds of arguments in response. One is empirical. And I'm no expert here, but I gather there's been a lot of data that the economists have put together suggesting that by certain measures, productivity being the one measure, productivity gains, which is kind of a proxy for innovation, have been declining the last couple of decades. That raises a question. And the question it raises, which raises the second point, is, okay, we have TikTok, but we don't really know the counterfactual, which is how much innovation would we have had if we had broken up the platforms 10 years.
But we actually do know, we have a really important piece of data on that, which is the relative rate of innovation in other advanced Western economies where antitrust is a little bit more aggressive, where GDPR is in place, and so they're operating in a much more highly regulated environment. And the answer is they are dramatically less innovative. And so, like, which are the big important tech companies that are based in the EU? And honestly, Japan, or even South Korea, right? These are enormously productive economies that don't produce this kind of produce giant platforms. And I'm so color me skeptical that there really is an empirical basis for the idea of that counterfactual.
I share your skepticism, but let me just, for the sake of argument, suggest a pushback that might be made. And the pushback might be something like this. Look, Europe, I remember when I was in the Justice Department, one of the people in the what we call then the foreign commerce section, which dealt with dealing with other competition authorities around the country, said at one point when we were frustrated about something that was going on in Brussels, he said, you have to understand these people are all former socialists. That may not have been fair, but one could say of Europe that it just doesn't have the entrepreneurial culture that has existed in the United States for a couple hundred years.
What about South Korea? It's an total economic powerhouse in all respects.
But just smaller.
It didn't start with the wealth and the access to venture capital. It's arguably now surpassing Silicon Valley. But anyhow, the point would be, maybe the problem is not in specific laws, but rather the culture. And we shouldn't go full right wing now and say, we have to abandon economic regulation because look what it leads to in Europe. That's the kind of pushback, but I share your skepticism.
Okay. David Botts, the floor is yours. Hold on, I'm trying to bring you up. Hello.
Hi, good afternoon. Thanks so much for letting me on. Thank you, Professor Melamed. I have a sort of a use case question regarding antitrust, and that is of our good friends from Amazon, where in the US, which I think is different than India, Amazon can play both sides of the ledger. They can learn with great precision what everybody is buying and at what price point they want to buy, and then they can make an affirmative decision to get into a marketplace, squeeze out the competition, and own that. I think the best example is Diaperscom, where they took it over.
Yeah, there are anecdotes like this. I'm not an expert by any means in Amazon. My understanding is it's less, it's not as broad a problem as critics have said, but there certainly are anecdotes. But the answer is, gee, why did they push Diapers.com out? It's because at the end of the day, armed with all of that data, and they happen to have access to lots more, they were able to build a better mousetrap. They were able to provide better service to consumers, and consumers chose them. Is that a bad thing? Well, you can argue that deters investment in rivals. The data on that are not at all conclusive. And if you don't have that problem, maybe the answer is it's a good thing.
Yeah, so going back to, I've just been rereading this, but Amazon's antitrust paradox, that Lena's paper, I think that her best case is actually something like Amazon or Apple, which I know that she inherited, like in this new administration inherited the FTC v Facebook complaint, so it wasn't like up to her necessarily. But one of the cases that she makes with Amazon is that they basically allow these smaller vendors to test new products. They observe how those sell, and then they banish the vendors or duplicate the sale of the products with Amazon Basics or things like that. And that type of behavior is, as you said, sometimes good for consumers. Possibly it limits inefficiency. But one of the things that really bothers me about Amazon, and I have the same complaint with Uber and a lot of different kind of floating pricing mechanisms, which is that you just don't know and don't have any type of visibility into the structure of the pricing. And so when they say something like 5% off or $5 off this, you don't know how much it's been inflated already to know whether or not you're actually kind of paying in some type of way. My favorite example of this is doing something like buying bobby pins and something like Amazon, where it's $8 or something to buy a set of 100 bobby pins. And if I walked to a CVS, it would be 99 cents. But the cost of the bobby pins is what they're not, it's free shipping, but they're basically saying that essentially the infrastructure, you're paying for the infrastructure of having it delivered. And so I'm just kind of I don't know, do you think that there's any type of intervention for antitrust in terms of that type of transparency around pricing? Or is that kind of something for other realms of the FTC in terms of, in terms of consumer welfare?
Well, I think misleading consumers, is something that comes within the consumer protection mandate of the FTC. And saying, there's a lot of law, I think there used to be, it's saying it's a going out of business sale when you're not going out of business, or saying it's 10% off. And in fact, it's always been the alleged net price and so on. Those are misrepresentations that are, at least in principle, unlawful. And you'd like to think we had enough cops on the beat to prohibit them when we think people are getting harmed by it. But that happens at the neighborhood store, probably more actually than on Amazon. I think the problem with Amazon, I thought you were going to say something a little different, which is we don't know what the criteria are that Amazon or Google or whatever are using to rank. Why did they put this first? Is it really some neutral consumer?
I mean, that's another thing. It's very much like who gets the real estate on the shelves in the store type of thing. And why is something Amazon's like gets a little banner like Amazon's choice. This is like the best, right? Like there's like a lot of little things like that. Yeah, I totally agree.
So when you go to your local store, if anybody goes to local stores anymore, you're going to see products arrayed on the shelf, and some are going to have the what I guess is called the end cap, the end of the aisle, which is thought to be the prime real estate. Others are going to be at eye level. Others are going to be down below. That didn't happen. Well, it happened in part because of a computer program that the store used, probably, but it also happened because vendors paid for that. They paid for privileged access.
Yes.
And we don't know that. We go into the store and we find Kellogg cereals up here and Posters down here, and we don't know why that is. Our eyes go to Kellogg and we buy that stuff. So the question is, should there be special interventions for Amazon because it's so big when it engages in practices into which we don't have a lot of visibility that are the same as the practices or maybe even less serious in the individual case of the practices that stores engage in all around the world? And the argument in favor of it, I suppose, would be that there's a little bit of a discipline when it's your local store, because if you don't like the fact that you can't find the Post cereal, you might have more luck finding it down the street. And if you really imagine that Amazon is the only place most of us go for online shopping, at least in the first instance, you care a lot about that. And then you start to think of something analogous to common carrier regulation. Well, don't we have to assume that they are the ones that, they're the train that everybody's going to take between towns A and B?
It acquires a weird net neutrality quality, right? Like they have to be, they can't treat their own, they can't privilege their own products, they can't promote with it. They have to be neutral arbiters of their own platform.
Well, it's not just their own platform, right? To make it sensible, it can't just be you can't privilege yourself. It means you can't discriminate with anyone, because otherwise you could circumvent the ownership threshold by entering into contracts with someone where in effect you get a kickback for favor of the other firm. So you'd have to have a non-discrimination regime. Okay, you have a non-discrimination regime, and what does that mean? That means I invent a new kind of online diaper service, and Amazon can't say that's a really good thing. I want to give it a break. I want to promote it so that it can get started. So
I also want to make a due deference to my friend Preet Bharara, whose family fortune came from Diaperscom.
I didn't know that.
Yeah, his brother was the founder of Diaperscom, and their slogan was "We're number one and number two," and that is how
I didn't know that is absolutely perfect. That's
was
amazing.
A fabulous slogan. So when the thing that was so threatening about Diaperscom to Amazon was that it was direct to consumer marketing, right? And it circumvented the retailer, which was Amazon. Well, now everybody's doing this, and so again, this is like, we say Amazon is this huge, is like a giant. It's the biggest retailer in the country now. But think about how many things you buy directly from the producer in a way that you just did not do 10 years ago.
That's true.
You buy, if you bought snazzy pair of, you want a pair of Uggs or Allbirds, you may just go to allbirds.com and order, so many entities do their sales, a huge percentage of sales directly now, that I'm not sure the comparison of Amazon to Walmart or Amazon to, it is relatively easy to set up your own distribution system, and lots of relatively small entities are doing it every day. And we actually buy stuff from people directly. And so again, I'm not really sure how to understand what the market is that Amazon is said to have a monopoly in.
Well, another way of looking at it is what are the obstacles to entry into that market, and to what extent are those obstacles a product of the size of Amazon as opposed to simply the efficiency and the value add of Amazon?
Mateo, I'm going to request, just because of time, that you just ask your first question that got
Sure.
most upvoted.
Awesome, no problem. This is a question I've been thinking about for a few weeks now, since Tom Wheeler was on to talk about the FCC. And it's concerning the potential for what I'm thinking of as like positive policy levers that the government might have to increase competition and consumer welfare. I think that at least when I hear talk about big companies that are big in a problematic way, and admittedly, this isn't like me listening to sophisticated legal scholars, they're usually focusing on regulations and corrections of a market failure that's already happened, as opposed to making it easier for new companies to get into industries that have a very high barrier to entry, like telecom or defense or sophisticated technology. And I don't think this is the sort of thing that the FTC can or probably should do. But broadly, I'm curious to hear your thoughts on these sorts of measures and their place in government response.
Yeah, I think it's a great question. It's a great question, because when you're dealing with big firms and you're worried about whether they could ever be displaced or within lifetimes of our grandchildren or something, what you're really talking about is entry barriers, and your question goes to the heart of that. My own view is that legislation to change antitrust law in this political environment is unlikely to be on balance constructive, but that targeted legislation designed to affirmatively reduce entry barriers to the big tech platforms that are the beneficiaries of network effects and other kinds of scale economies might be really valuable if done intelligently. And I see them as falling basically into two buckets. The first would be a legislation that would make it reduce switching costs among users or advertisers. So so-called data portability. I can take my record of purchases from Amazon to another platform. I can take my social stuff from Facebook. I don't use Facebook either, to wherever I want to take it. So it's easier for me to switch. And the other is ones that would allow the newcomer to tap into the network effects and some of the economies of the big platforms by interoperating, by plugging in the Ben Wittes social network into Facebook, so that somebody on Facebook can reach somebody on the Ben Wittes, the new Ben Wittes Facebook, Ben Wittes platform.
Truth Social.
Right. Okay. So I think that's a great question, because I think it points in the direction that is most likely to be fruitful in terms of new interventions into this space.
Yeah, I mean, we have to close, but I love that idea. I think that you and I have talked about this separately, but the interoperability is kind of like the key. I think that even going back into history, AOL and Time Warner, and I think I've made this point to you before, maybe I did, was that the AOL Time Warner merger, one of the underappreciated conditions of the merger was that AOL make its instant messaging platform, or its instant messaging feature on its site interoperable and open source, so that it could like be used with ICQ and MSN Messenger and other types of instant messenger. And one of the things that was interesting about that, and I'm writing this in this paper, one of the things that's interesting about that is that it kind of turned out that I think AOL did not have a fulsome kind of concept of how people were using its platform. And I'm not sure this is like as true now as it was then. But like it was, as you remember, AOL was subscription based. You paid per minute that you were on the site. And it was also ad based. Like you were served a number of ads. And like people just were not using AOL to browse. They were using AOL to sit for hours and chat with their friends. And this was like how they were paying for the service, essentially. So like what's really fascinating kind of about this example, I think, is that there are direct corollaries to kind of like the cluster of services that these platforms provide that all kind of have these like similar types of effects. You use it for email, and you use it to chat, and you use it to see the news, and you use it to do whatever else. that if you could unbundle direct messaging, which is a feature of TikTok and Snapchat and Match.com and like, Grindr, all of these things, like they all have instant messaging type capacities. And so I'm just I think that those types of regular interventions might just be kind of like very slightly more soft touches than kind of the structural breakup that's being called for.
I agree with that. Yeah. There are interesting questions of compensation, but that's for another day.
Yeah, no, totally. Doug, this was so fun. Thank you so much for coming on, talking about your paper, talking about antitrust. I don't know. I think we kicked, I'm sure that Amazon at any moment, Jeff Bezos is going to come and ask us to like advise him on how to avoid antitrust enforcement against him. Or
he should come on in lieu of fun and discuss it. And, we can talk to him about the anti-competitive price of dog shirts on
They just become anti-competitive with you, Ben, because they know that you keep looking for them and you
buy
them all up.
Yeah.
Yes, exactly. We will be back on Wednesday. Who is our guest, Ben?
Who is our guest on Wednesday?
It's Amanda Tyler. Amanda Tyler. She's going to be on at Berkeley Law. She is an expert in habeas corpus, and she's going to be talking about the book that she co-authored with Justice Ginsburg. And that will be many hours from now. And until then, Ben?
We don't have fun anymore. And we don't have agreed upon principles for antitrust in the big tech age either. So,
I thought you were going to say we don't have interoperable dog shirts. And I was like, we kind of do.
No, dog shirts are all interoperable.
Yes, exactly. Bye, Doug. It was great to see you.
Take care.